Welcome to Estate Planning Fundamentals. We're just going to go over why do we have to participate in estate planning, some general myths around it, and kind of what the key documents are, what to expect from a great estate planning lawyer. So who do I think I am that I get to come and talk to you about this? So my name's Patricia and I have my own estate planning firm. I have 2 attorneys who work for me, and we have a support staff, all military spouses. We are all mothers. My team and I have won a torch award for ethics in business, which is pretty rare for a law firm, I've been told, by the Better Business Bureau. I'm also published on their blog for estate planning and business owners. Without asking anyone to vote for us, we've won Best of the Best and Bay Area Parent, I think 3 or 4 years in a row. So that's always nice to see because those are clients and people who have come to workshops voting for us. I've also been awarded the super lawyer designation. I think I'm on year 4 for that. And this is peer review and peer recognition. So that's a pretty important accolade for an attorney. You can't buy a super lawyer designation. You have to be awarded. I'm also a contributing author. I write about estate planning a lot. In this compendium, it just happens to be about estate planning and the divorcing client. And I'm also a nonstop, you can't take me off the air podcast guest. And if you want to listen to me talk about estate planning for a really long time, you can listen to some of the podcasts that are on our website under the section called Panels and Podcasts. So the basics. So estate planning matters because the state of California has an estate plan for you and you need to opt out of it. Nobody has the authority to make medical decisions for you, and nobody has the authority to talk to your employer or use your money to pay your bills. No one has any authority. And I know it feels like we have no privacy in this world, but if you don't give the right people permission to make decisions for you, to act for you, you might be subject to conservatorship. So what that means is that the court has given a third party permission to act as you and make decisions for you. And hopefully it's someone you love and not someone who's trying to control you. But even if it is someone you love, it's tens of thousands of dollars, it's public, and it's catastrophically upsetting. So we don't want to put our people through having to get us conserved. If you don't have a revocable trust, then your estate, everything that you own, goes through a process called probate. And there are little mini probates for married couples or people who have very, very de minimis assets. But generally speaking, a probate is the transfer of your stuff onto whoever is going to get it next. If you've done nothing, then the statute says who gets it next. If you have a will, then your will says who gets it next, but it's all a completely public process, and it exposes all the people you love who are named in your documents to creeps, creditors, and predators, because all of this information winds up on the dark web. People who are grieving are wonderful, excellent marks for the nefarious. And then there's the minor children. A typical scenario is date night, you're out, you're not coming home that night, police officer goes to the house, kids are home with a teenager, now what? The police officer gets to decide where to place the children, and that's wherever it's necessary, convenient. So that's one scenario. Is it Child Protective Services? Is it your neighbor you don't really like? Is it a family member you don't really like? Also, you have to remember that while you get to appoint people in charge of your healthcare, you get to appoint the people in charge of your insurance and your mortgage and all the contracts, Comcast, all the way up to the nursing home, you get to appoint the person in charge of your money. You nominate the person who would be the guardian of your children, because the judge is always going to take a second look. So it's really important to not leave a judge to just say, well, the sister seems fine. You want to make some really affirmative statements around who you want to have in charge. Everybody thinks that estate planning is for old people and rich people, or that they have a wonderful support group and great family and everybody's just going to do the right thing. Or they think, oh my gosh, did it. I just can't handle it. We've all seen the GoFundMes. We've all seen these for widows and widowers. Estate plans can help avoid a GoFundMe. Estate plans, sure, rich people have them. And, most of the tax laws are written around them trying to defer tax. But if what you have is a piece of real estate and a life insurance policy, if you don't engage with estate planning, your stuff is going to wind up going through that probate court, and the people that you're leaving behind are going to be exposed. They're not going to have any asset protection. It's just going to be a bit of a mess. And so doing nothing because you think you don't have much actually puts your assets more at risk. It's wonderful to trust people to do the right thing, but they need instructions. They need to be told what to do because you're asking them to do things in a time of absolute chaos. And maybe some of your family members think you want to be cremated and others know that you want to be pressed into a diamond. Maybe some of them think that you would want in-home care and others know that you want to go to a nursing home. You can't leave it to people to try to figure out what it is that you want to have done. Estate planning is too complicated. It's not complicated. We talked about conservatorship, probate, and then children going where it's necessary and convenient. So estate planning just addresses, what about me? Who's in charge to take care of me and my stuff? What about my stuff? How do I make sure my stuff goes to the people I want it to go to in a way that honors and protects them? And what about my kids? How do I set things up so that when a judge is determining who the proper guardians of my children will be, that my voice has been sufficiently heard, that mistakes are not going to get made, and that people who want to get a hold of my kids because they think they're going to get a hold of my money are cut out of the picture. The last one's really important. Estate planning is not a one and done. It's really, really critical to review your estate plan every 3 to 5 years with your estate planning attorney. Why? You might think everything is fine. All the same people, all the same stuff. I put all the stuff in the trust, nothing has changed. But you don't know if there have been changes in the law. And it's not just the federal laws related to taxation. A judge in Fresno may issue an order that has an impact on the way that estate planning lawyers do or don't write deeds. In the last few years, we've had Prop 19, which really changed inherited real estate. And we had the Secure Act, which really changed inherited retirement accounts. So you always have to come back and refresh. And if anybody that you love in your life has said, oh, we did that 10, 20 years ago, please drag them back to an estate planning lawyer, especially if you're named in the documents, because chances are they will not work. So let's dig a little bit deeper. We've said that estate planning is what about me? What about my stuff? What about my kids, my people? So what are the documents? A healthcare directive and a HIPAA waiver. You can get these from your doctor, and you should. If you haven't done them yet, I encourage you. Your doctor will be so happy. You will get a better, more robust one from your lawyer, but you can absolutely do an advanced healthcare directive on your own, and you can get a HIPAA waiver from your doctor also. A power of attorney, you can do it on your own, but the problem is the banks probably won't take it. You have to imagine being that person at the bank, and someone comes in with this document. It's not countersigned by a lawyer. There are no other forms around it. The bank is probably going to think that that person is trying to take advantage of you, and they're going to kick that document up to legal. So a power of attorney is something you generally need to do with an attorney, so that might hopefully actually work when the time comes, because it's always the entity on the receiving end that is going to be suspicious of the document. When we talk about what about my stuff, we need to avoid probate. A well-crafted revocable trust provides privacy for you, your surviving spouse or partner, and for your kids and other beneficiaries. It also gives you a lot of really neat control from the grave. You don't have to leave your assets to your kids when they're 25, 30, and 35. You can be a lot more creative than that. We can craft a trust that says, every year I want the children to go to Guatemala to spend the summer with their grandmother. The trust is going to pay for it. A properly drafted trust will also have tax planning and asset protection planning for a surviving spouse or partner, but also for your children and maybe for any other beneficiaries. Giving money to people outright can hurt them. 33% of people who inherit money lose it within 3 years. Not because they're bad people or they're drinking it. It's that people come around when you're most vulnerable and you have this pile of money that makes you feel terrible and you give it all away. And so we want to protect people from that. It's important to know that when you create a revocable trust, that doesn't mean that your assets are protected while you're alive. That's what insurance is for. That's what LLCs and corporations are for. If you transfer everything to your revocable trust and you fly to Vegas and you walk up to the roulette wheel and lose everything, you haven't violated the terms of your trust. You can do whatever you want with your stuff, right? You can transfer your house to your trust and then sell it. It's not a problem. But that also means, because you have so much control, that you don't have any asset protection. When it comes to the children, I mentioned that it's a judge who makes that decision. So we don't want to just use a will to name the guardians. A will is the only document in your entire estate plan that will absolutely wind up filed with the court. It becomes a public document and everyone can see it. So I don't like to name your children in your will, and I certainly don't want to name the guardians in the will. Imagine being home and you've lost your co-parent, your spouse or partner, and now everyone knows that you are home alone with these minor children. Grifters, predators, all kinds of creeps and weirdos. And it's the same scenario for your guardians. We have to maintain their privacy. At my firm, we do a very long form guardianship nomination form. We say, here are the emergency contacts. Here's who we want the guardians to be in case we become incapacitated or when we die. And here's who we don't want and why. And here's how we feel about religion, education, where our children should live. Here's a list of people who know us well, and we want our children to have access to these people to hear the stories about us as they get older. Here are our traditions. Here are our values. What's really neat about this document is anytime I work with one parent, they've split from the other parent, we give this to the other parent and we get a great result of either oh my gosh, that's so touching. I'm going to do one also. Or they get really jealous and they say, I'm going to do a better estate plan than you. And they go off and they do their own plan. And who wins? Children. Children win, right? So now both parents have an estate plan. It's really important to choose the right people to serve in various roles. Usually when you see intake forms for an estate planning firm, it'll say, healthcare proxy, attorney in fact, or agent under a durable power of attorney. And it'll say successor trustee. You have no idea what any of that means. What does it mean to say that someone's going to do this work? My intake forms say, if you bump your head, who's in charge of making your medical decisions? If you bump your head, who is the person that should be in charge of your taxes and your mortgage and your retirement accounts and your employer? When you die, who is this person who is going to manage all of your assets and distribute those assets or invest those assets? And so this can be quite a few different people. Even within your trust, it might be that you may want your sister to serve for you if you bump your head and your partner's not around. But your partner may want their own sister to serve if they bump their head and you're not around. And then it might be that you choose another person to be in charge of the final tax return, marshaling all the assets, paying off all the final bills, doing this enormous amount of work that needs to be done within the first year after you die. And then it might be a different person who's going to manage those assets for the long term for the sake of the children. So there are lots of ways to slice this up. And the intake form that you fill out should only be a starting point for any attorney. It's not something that they should use to draft your documents off of. It should be just a little something to get you thinking about your people. And then the lawyer double and triple and quadruple checks that all the people are the right people. And then we have them serving in all the right roles. Funding your trust is a drum I will never stop banging. Your estate plan will not work if you do not transfer your assets to your trust. It is critical. So a few stories to make this real. So when we think about what about me and conservatorship, here's a really common scenario. Didn't wind up with conservatorship. She was married to her husband for 40 years. He gets in a terrible motorcycle accident. She gets to the hospital. He is on life support. He's not waking up. Massive brain damage. She says, unhook him. He would not have wanted this. This is terrible. Take it all off. While she's saying this, his mother comes into the room and she says, absolutely not. You will give him a feeding tube and you will send him to a nursing home. So for the next 4 or 5 days, every morning the hospital called at 7:30 in the morning, come to the hospital. You have to talk to the doctor, the nurse, the hospitalist, the hospital administrator. You guys have to make a decision because we need the bed to actually treat someone. We cannot have this person just sitting in the hospital, but we're not treating them. You have to come to a conclusion. So they did. And the wife and the mother do not talk to each other anymore. 40-year terrific relationship is over. So we don't trust our people to know what to do. We have to write down and tell them what to do. You have to be really, really clear so that if you have to stand in front of your mother-in-law, you can say, oh, we talked about this. And if you work with Devonte Law, you talked about it. You talked about it in front of your lawyer. You did a whole workbook about it. And then you shared your advanced healthcare directive with your loved ones so they could ask questions well in advance. Because this is the kind of thing that'll tear our family apart. This happened in my family. There was a woman on one of the mom Facebook groups, and she had 2 young children, and she was living with her new fiance, who was not the father of her kids. And it was his house, and he died. And her parents threw her out of the house. She's not on deed. He didn't leave her anything. It's a little scary. And even married couples, you have some separate property sometimes. That doesn't automatically just go to your spouse when you die. That might go to your kids. And so if your separate property is your real estate, all of a sudden your spouse is dealing with a minor who has real estate. And the court has to appoint a guardian ad litem, and it gets very, very complicated. I talked already about using a will to name guardians for your children. Outright distributions can and do hurt people all the time. If you want to leave money to someone who has a lot of problems or just isn't good with money or is receiving social services, there are other ways to do it within your trust. I worked with a woman who was leaving all of her assets to charities. I asked her about her family, and she told me all about her brothers. And she loves them. I said, you love your brothers. They're not doing great economically. You have a lot of money. What is going on? Why are you leaving everything to charity? And she said, well, if I leave them the cash, they'll drink themselves to death. I said, okay, so the last lawyer you worked with didn't tell you that we can create mini trusts for the brothers to pay for their healthcare, their recovery, to serve as a safety net for them without actually giving them money. And she burst out crying. She had no idea that that was an option. It's really important that whoever you work with, they don't just do what you tell them, but they ask you a lot of questions about what your goals are, because she was absolutely blown away that she could, in fact, take care of her 4 troubled brothers. And just a note about when fair is not equitable. Thinking that your kids are going to buy each other out of the real estate is not an estate plan and actually subjects them to income tax. It's dangerous. When one of your kids has a lot of money, the other one has very little and has trouble, we need to think about, is it a 50-50 split, or are the concerns greater for the kid who has problems because we want to pay for recovery? We want to make sure that they don't burn through their half and then turn to your other kid. And it's really important to think about who it is that you're putting in charge, because you don't want to put one of your kids in charge of all of the kids' money. So what else does a good estate planning lawyer do? They're going to draft you these brilliant documents that address absolutely everything about your specific situation and your specific assets, your business, your real estate, your retirement accounts, your RSUs, all of the things that you own. We're going to put all the right people in charge. But what else? What's probably going to happen after you sign your estate planning documents is you're going to live for a good long time and everything's going to be great, but you're going to have all kinds of problems with tax, and you're going to have all kinds of problems with insurance. You're not going to save up enough money for college. So you need a team. You need to not ever DIY your insurance, whether it's renters all the way up to long-term care. You need to work with brokers. It doesn't cost more. It's hard to find a good broker. That's part of what my team does to help you. Maybe you need a money coach or a wealth advisor, right? There's a whole spectrum there. We can help you vet one, and we actually give you a template on how to interview a financial advisor, how to interview a CPA, because are you doing look-back taxes or are you doing tax planning? A good estate planning lawyer is going to look under the hood. We're going to explain what your deed says and tell you exactly how you own things and what the tax consequences are. We're going to talk to you about your business. Is it formed properly? Do you have business counsel? Is it insured? What happens when you die? Should it be sold? Should it be dismantled? Who could be in charge of that? Businesses are tricky and specific, personal, so we have to get it just right. We're going to talk to you about all of your insurance, and we're going to look at everything. I have a PhD in paranoia. Everyone on my team has a PhD in paranoia. So we want to make sure that you are set up for success in the whole 360 view of all of your assets and your people and your stuff. We're going to send documents to your advisor. We just send a little 2-pager letting them know the exact name of your trust, and we provide instructions to them as to what it is that we want them to do. We turn them into our spies, because you're going to be with us for maybe 3 months, but you're with your tax person, your insurance person, your financial advisor for the long run, and they can make sure that you are actually doing your ownership changes and your beneficiary changes, that you're keeping up with your trust maintenance. It's also important that the people that you are entrusting with your children or to serve for you, your agents, all have estate plans. We want them to be organized. And then also your other family members. I provide referrals for estate planning lawyers all over the country to help my clients make sure that their parents have good estate plans. So how do you vet an estate planning lawyer? A lot of us are certified specialists or we have an LLM. And what that means is that we've taken a whole bunch of exams to prove that we know what we're talking about. And I'm not a certified specialist because I'm never taking another exam again. As long as I live, the LLM was enough for me. You want to make sure they've been doing it for a while. There are a lot of estate planning lawyers out there who've been doing it for a couple of years, but they were basically working as almost a paralegal at a bigger practice, stole forms, and are using those forms to practice estate planning. It's dangerous. And so I want you to make sure that you always ask, do you use software? Because unless you're working with a firm with like at least 10 people, they should be using software, because it's really hard to keep up with all of the documents and all of the law and all of the best practices if you don't have a really big team. And so my team, we use Wealth Counsel, and it's recognized by the American Bar Association. It's absolutely gorgeous. The documents are long, but there are really robust tables of content. Other practice areas, if they're doing trust administration and probate, okay, that makes sense, right? Because these are all things related to what happens to your stuff. If they are doing bankruptcy and family law and entity formation, I have concerns. If it's a much bigger firm, fine. But if you're talking about a practice with 1 or 2 lawyers, you shouldn't be seeing all these different types of law. And the emotional connection is really important. You have to tell your estate planning lawyer about all the fragile people in your life if you're going to leave them assets. And you have to tell us that, your step sibling has sued absolutely every family member for absolutely everything, so that we know we can counsel you on what your options are when it comes to your plan. I know that you're all looking at the pricing. So major metropolitan areas in California, this is pricing for a basic plan. I hear all the time our assets are really simple. It's not so much about the assets. The assets are what they are, and it can get complicated if you have complicated business structure. It can get complicated mostly because of your family, mostly because of your people, but even in a plan that is not complicated at all, we still need to talk to you for a long time to figure out who everybody is and what everything is. We still need to review documents with you. We still need to teach you how to fund your trust. And we still need to prepare all of those documents. All of this takes a lot of time and care. I want you to look for lawyers who are going to meet with you for at least 4 hours and 3 meetings minimum. And you have to work with a lawyer who will follow up with you. You can't work with somebody who just hands you your documents and sends you off to have them notarized, or who just tells you, I'm never going to talk to you again. This is not a healthy situation. So the client experience at my firm is a 20-minute complimentary consultation. You get to ask us a bunch of questions. We're going to ask you a few baseline questions and just see if generally we are a match. Then you're going to fill in some intake forms. Just need a general idea. I want you to just spend an hour on those. And then we have the lawyer's learning meeting. And we call it that. It's 2 hours. And all that happens in that meeting that you get to come to on Zoom in your pajamas, we're going to ask you a lot of questions. A lot of questions about your families, a lot of questions about your stuff. Once we know who everyone is and what everything is, then we can get into who's in charge in different scenarios and who gets what when. We'll then send you draft documents to review, but we know you're not going to read them all because it's too much. And so we send really detailed instruction on how to do the review, how to give us questions and revisions, and we really boil it down to look at maybe these 20 pages, because that's the most personal part of your plan. Then we're going to get together for the client's learning meeting, and we're going to review those documents together, section by section, sometimes line by line, to make sure that you understand what you're giving people authority to do. And once we get through that advanced healthcare directive and you see all the options and all the things that you're going to instruct, was your cousin the right person? Should it be your best friend instead? How are we dealing with this? How comfortable do you feel now that we've read the document together? It's the same thing with your trust. It's the same thing with your powers of attorney. Same thing with the guardianship nomination form. We have you sign your documents either online or in person, whatever works better for you. Most of our clients opt for an online, like Saturday morning. And then we have one more meeting. We'd like you to bring your financial advisor. That's when we talk about title changes and beneficiary changes, because your stuff has to flow through your trust in order to benefit beneficiaries when it comes to tax planning and asset protection. And then we have our complimentary client service package, which is a free meeting every 3 years, our newsletter. Sometimes we do events. We check in every year. It's all of the follow-up that we do, sending your advisors copies of your certification of trust so that they could do all of the spy work that I mentioned earlier. So it's a really robust client experience, and it generally takes clients 4 to 12 weeks. We find with brand new babies, closer to the 12-week mark. But if you're really motivated and you're leaving town and you just want to get it done, we can meet you where you are, go much faster. So who do we work with? We do a lot of work with the LGBT plus community, and we have very specific language for the LGBT plus community that we put in our healthcare directives, powers of attorney, and our trusts. We work with married, unmarried, and single people, and working with my first throuple right now, and they are so cute. I work with a lot of artists, creators, and performers. I have a background in intellectual property, was a copyright lawyer and an entertainment lawyer. And so clients who have copyright interests, clients who are performers, they're really invested in what would happen to their image and what would happen to their work after they die. Not every artist is comfortable with their art being turned into a shower curtain for sale at Bed Bath & Beyond. And so we work with them on that. I work with people who are contemplating going through divorce and post-divorce, very specific type of client. We don't charge extra, but there is a lot of extra work that goes into working with someone who's going through a divorce. For the real estate owners, probate. You have to avoid probate. And then business owners, I touched on that earlier, that it's very specific to each type of business. So we really have to get into, what are we doing in this business if you bump your head? What are we doing with this business when you die? Are there business partners? And are there any restrictions on who can actually get into the business if you have licensing issues? And thank you. Thank you for taking the time to listen to me do this. Thank you for being interested in estate planning. I hope you feel inspired. I would leave you with, you've come to this or you've watched this. Please, like within the next 48 hours, schedule a call, either with me, or if you just didn't like the sound of my voice, with any other lawyer that you like. This stuff is important. We never know what's going to happen when. You will never sleep better than the day that you sign your estate plan.